A person at the jail, please state your name for the record.
James Eddy. James Eddy.
This is case number 254894 SD. Mr. Hetty, you are here on an alleged bond violation that you tested positive for alcohol on December 25th at Community Corrections. If you are found to be in violation of your bond could be revoked. You do have the right to have a contested hearing in this matter, where the prosecution would have to prove to the court that you did in fact violate your bond by testing positive. Mr. Harrison, how are we proceeding today?
My guess is that Mr. Hetty is prepared to make an admission, but that may not be correct. The last time I spoke to him, that was his voiced intention.
Mr. Hetty, is it your intent to plead guilty to the bond violation today?
Yes.
Or did,
With
right.
reason, if it would have explanation. I did not intend to get
okay,
myself.
hold on. Before we get there, have you had adequate opportunity to discuss that issue with Mr. Harrison?
He had a representative.
Or with another attorney?
Yes.
All right. Has anybody promised you anything in order to get you to plead to the violation?
No, I just want to be completely honest because you were so kind the first time we talked.
All right, so then to the allegation that you tested positive for alcohol on December 25th at Community Corrections, how do you plead?
Guilty with explanation by me.
All right, we'll get to the explanation in a minute. Is it true that you had tested positive for alcohol on the 25th of this year or this month, Christmas Day?
Yes.
And had you consumed alcohol prior to
The
testing?
evening before.
Right. Okay.
I was, if you want explanation, I can explain.
Okay, go ahead now.
My brother and me were showing up at mom and dad's, and we were having a prime rib that evening, celebrating Christmas. And my brother had brought a platter of pudding cups, I believe they're called, and they're butterscotch. And I knew the punch had alcohol in it because my mother put champagne in it. And I had eaten 3 of those butterscotch because I didn't tell my brother I had been arrested. He didn't know whether to tell. I did not know they were full of vodka. And I had 3 of them, and I see my number the next morning and headed in. I was actually surprised when she told me I tested positive because I didn't recognize what I had done. I didn't have a chance to talk to anybody to figure it out. I laid in jail for 4 days, and I think that had to be it.
Well, it looks like you told Ms. Stark that it was a strong orange juice.
I didn't know because when I'm sitting there talking to Miss Stark, I'm trying to figure out where it came from.
Okay.
I had orange juice for breakfast, and I'm thinking, is it tart? Was that where it came from? Because I was actually mystified.
All right. All right. Well, the court does find that the defendant is in violation of his bond conditions. He was ordered not to consume alcohol and subject to random testing. He did appear. It looks like there was some discrepancy as to when he may have been there originally, but he did appear on the 25th and tested positive for alcohol. So the court does find him in violation. That brings us to what to do with his bond. Mr. Harrison?
Well, Your Honor, given his brief prior history prior to this matter, and giving, I don't know if the court is aware of some of the facts and circumstances surrounding the underlying charge. It was, I don't know how to classify it. In other words, I don't think he is a serious menace to society here. Obviously, this is another perhaps misidentification or mistake on his part. The underlying case involves consumption of a couple of cocktails at a local watering hole, and a short drive later after he was encountered by the officers. Despite the fact that he shows a proclivity for using alcohol. It's rather ironic to both he and I, because he's not a heavy user at all. So I would regard this as a blip on the radar, small mistake. He's been otherwise compliant with testing despite the hiccup in the timing on Christmas Day. As far as I know, I would recommend that the court leave his bond where it is. We intend to resolve the underlying matter forthwith, and perhaps we could address any additional sanction or things like that at that point.
Thank you, Ms. Lawrence.
Thank you. I'm gonna leave this one up to the court. I don't know if I necessarily believe everything Mr. Eady is saying that occurred. It is a little bit concerning that the underlying charges is not only operating while intoxicated, but also a high VAC in this case. So that does raise some concern. I am told by Ms. Matsky that other than this incident, he has been doing well on bond. So I will give him credit for that. So I will leave bond up to the court.
Thank you. As Ms. Lawrence pointed out, we've not had any violations with the defendant since he was placed on bond back on the 20th of November. I do find it a little odd that grown people are sitting around doing pudding cups or Jello shots, whatever the case may be, and doing multiples of that without knowing that there's alcohol in that. However, the court will continue the bond as previously set. Ms. Matsky, will he need to get signed back up for testing again?
No.
All right.
You'll put it back in the system.
All right. So Mr. Hetty, at some point today, you're going to be released and you're back in the testing system. So just make sure that you're checking those numbers. All right.
Thank you very much. I won't lay you down.
Thanks, James.
Next arraignment. Person at the Wexford County Jail, please state your name for the record.
Christopher Lee Bowler.
This is case number 25-5160FY, people of the state of Michigan versus Christopher Lee Bowler. Sir, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the Defender's Office today?
Yes, sir.
I have a complaint that alleges that on or about December 23rd, 2025, in the city of Cadillac in Wexford County, it is alleged in count number 1 that you committed the offense of police officer assaulting, resisting, or obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. A consecutive sentence may be imposed if it happened in a place of confinement. Additionally, the prosecution has opted to charge you as a habitual offender fourth offense notice. That means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 2-year felony a 15-year felony. Now, I'm going to state for the record that the prosecution had also charged you in count number 2 with malicious destruction of a building, $1,000 or more, but less than $20,000. The court reviewed the probable cause affidavit this morning, and it on its own sua sponte is going to dismiss count number 2 without prejudice, meaning that it can be brought back, because the probable cause affidavit does not make out that count. You have a question, sir?
Yeah, what do you mean by dismiss? It says like not by prejudice. What do you mean by that? Like dismiss not by prejudice?
So I dismiss count number 2
Okay.
without prejudice, which means it can be brought back with more information. Just the affidavit of probable cause that was filed with the court does not make out sufficient enough evidence for that charge to be authorized. But it is possible that it can be authorized in the future. Do you understand that?
Yeah, yep.
You understand then those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to have an attorney at all phases throughout this process, and if you could not afford one, One would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request an appointment of attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the probable cause conference, prior to the preliminary examination, there'll be a probable cause conference. And that's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing in a future court appointment, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 19, I show a false report of a misdemeanor. In 19, operating without security. In 20, a domestic violence, assault and battery, abandoned cruelty to one animal, malicious destruction of property, 200 to 1,000, an attempt to resist and obstruct. In 21, an attempt to interfere with electronic communication and in domestic violence. 21, possession of meth. 21, malicious destruction of a building, 200 to 1,000. 21, use of meth. 22, possession of meth. 22, resist and obstruct. 2 are no's out of 23. And in 20, there was a resist and obstruct a conservation officer and use of methamphetamine. It's also my understanding that the defendant is currently on parole. And the praxis scores him at a risk level 6. Comment regarding bond, Mr. Harrison?
It's largely academic in light of the parole hold. We understand it's Agent Simmons. We intend to consult with her, obviously, the potential impact of the disposition of this case. I would have the court set a bond, simply in light of the opportunity we may have to resolve the parole hold in a timely fashion, however remote that may be.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I was told that MDOC does want him back. I have very limited information on that, and I'm quite frankly not quite sure how that works. So I am going to ask for a larger monetary bond in the meantime. The defendant, there's some serious issues here. I understand probably some mental health issues, but he was extremely uncooperative with not only the parole agents in this case. He had butted a wall. He continued to say he was going to kill himself. He threatened to spit on officers. A sergeant actually had to ride in the back of the car with him to the jail because he would not cooperate. This seems to be an ongoing issue given his criminal history, so I do think a monetary bond would be appropriate in this case. I will leave that up to the court. Thank you.
Thank you. Well, the court does find that the defendant is both a flight risk and a threat to the community. I find it as a threat given the domestic violence charges in his past, the interfering with electronic communications, and the several resist and obstructs in his past. Also, for that same reason, I find him as a flight risk for fail to comply with law enforcement officers. My reading of the probable cause does indicate that he perhaps destroyed a desk in the probation and parole office, put his head in through a wall, or at least broke the drywall while bouncing his head off of it, bounced his head off patrol vehicles. So I do believe a monetary bond is appropriate. Bond will be set at $25,000 cash surety with conditions that you appear as ordered, keep your contact information current, not leave the state without permission, and commit no crimes. You must comply with DOC. That you not act in any threatening, intimidating, and harassing behavior, and not to purchase any firearms or weapons. Next, Raymond.
Your Honor, that was